Hey, I just have a question. If I have a living trust and I have my daughter on it, she was under 17, and I put my sister in charge, in case I ever pass away. But now that she's an adult over 20 years old, would I need to keep my sister on that living trust still, or what would happen?
So you're talking about who would be your successor trustee, who would manage your trust if you passed away, David. When you initially set it up, you appointed your sister because your daughter was younger. Now your daughter is older. I assume that she's mature enough to do this job for you. So what you would do would be to amend your living trust and make your daughter as the first choice to be your successor trustee if that's what you want to do, David.
Gotcha. Okay.
Hey, David,
Perfect.
how old is your daughter, by the way?
She's going to be 21 in May.
So, David, let me ask you, and by the way, does she inherit your wealth when you pass away?
Yes, I have her down as beneficiary and also on the trust.
And the trust, David, does it say something like that? If your daughter happens to be under the age of 25, her wealth, your wealth would stay in trust to be used to help her go to college, help her buy a home, and she doesn't get it until she reaches age 25. You might find that language in your trust as a kind of standard procedure. Do you think that's in there, David?
That I'm not too sure, Tom. I'm going to have to look it over real good for that living trust, because I know I left everything for her, in case I pass away with my wife, and I know I put my sister in charge, because she was under 18 at that time.
Okay, so
I have to
David,
look it over.
if your trust states that your daughter doesn't get the money until she reaches age 25, all in all, David, I'd recommend that you leave it the way it is. Your sister would continue to be trustee. And then once your daughter turns age 25, then consider adding her as the trustee. And David, what we're talking about is that if you and your wife both passed away and you guys got $1 million, it might be unwise to hand $1 million over a 21-year-old. It may not be used for the purposes you want it to be used for.
Right, I understand that.
Okay. Thank you, David. Holly, when we do trust for people, we're using them for a couple of purposes. Purpose number one is to help people to avoid probate.
Yes.
Probate's expensive and takes a long time. But we're also using it for people who have younger children so that their children, in the trust, the client gets to dictate at what age their children would get this money.
Absolutely, yes, they can do that with a living revocable trust. Mm-hmm.
And our standard trust, the pre-printed form itself, states 25, age 25.
That's our default, age 25. And, the reasoning behind that, Tom, is, a 21-year-old is just that, 21, and probably still in school, focused on school and other things. And so it's nice to know that there's this default of age 25 where if something did happen to mom and dad, whoever they appointed as successor would be managing it for that 21-year-old, that 18-year-old.
Yeah.
And I find it's a good provision.
So David said it was his 21-year-old daughter, which means she's probably got the maturity level of a 28-year-old. If David had a 21-year-old son, he's probably got a maturity level of about a 13-year-old.
Yes.
So, when I hear daughter, maybe. If I hear 21-year-old son, no way. So when we talk about age 25, keep in mind that if you pass away and your child is under age 25, your successor trustee can use that money for certain purposes.
Absolutely. For the care and maintenance and help on behalf of the child, medical, school, trade school, they need a car, they need an apartment to live in while in school. Whatever it is that would assist and help the child before they turn age 25.
So there is access to that money, but it is at the discretion of your successor trustee. In this situation, it was David's sister.
Mm-hmm.
So if they follow this plan that we're suggesting and they both pass away and the daughter goes to the sister and says, by the way, I can drive. I'd like a new car now. I'd like it to be a Corvette. Sister could say,
no, you're going to get a Honda Civic.
There you go.
Hybrid.
So that's the important part. Now, this is age 25 as our default, but when we're doing trust for people, we certainly make them aware that here's some other choices.
Absolutely.
Sometimes people will say, okay, for my kids, they get half at 25, half at 30, knowing that they're going to blow the first half, but hopefully they'll be older and wiser at 30 to hold on to the second half.
Mm-hmm. We do see that quite often, and I've seen that just recently where a client has asked that we do just that, where they get a certain percentage at age 25, age 30, and the rest at 35.
At 35, exactly. Sometimes we got people going up to age 40, and sometimes we have clients that they did not inherit their wealth. They worked hard for every dime they've ever owned.
Yes.
And they want to make sure that their kids work for their money before they're handed this pot of gold, you might say.
Absolutely. Yes, indeed.
Because we know, and I'll bet most of the listeners know, what happens to a lot of trust fund babies.
Ooh, they go off the rails.
They don't, it doesn't come out well.
It doesn't end well, or there is a period of time where they're really struggling only to come out losing in the end.
Yeah. And so that's just something to consider, that making your kids earn it before it's given to them.
Before it's given.
Now, what is odd every once in a while, Holly, is I'll have a client and their children are 45, 50 years old, and they're saying, Tom, when we pass away, we want their share to stay in trust until they reach age 65. And these clients are telling us that, man, they got a 45 or 50-year-old child that hasn't managed to save a dime their entire life.
Their entire lives. Mm-hmm.
Yep. Mm-hmm. And so what they're saying is that they want to this money stays in trust until they basically age of retirement, and hopefully by then they understand that, boy, they better hold on to this because they're not working forever, and they got nothing in savings. This is what they're going to live on.
This is it.
Yeah. Hey, folks, my name is Tom Olsen, and the name of the show is Olsen on Law. We're going to take a break.